Hi, guys. My name is Attorney Walter Rudolph Hnot III. We're just going to start off right off the bat and say we're going to wait for a few people to actually join in with us. Now, let's go ahead and talk about, real quick, to begin our post, our two quasi-sponsors. Quasi-sponsor number one is Beaver Moon Soap. They let me buy their soap cheaply, and that's really cool. I don't know if that makes them a sponsor, but it doesn't really matter because I like their products. So I'm going to put it out there, shine a little light on it. Today's soap is Bay Rum and Lime. It smells really good. Then begin. All right. So the next sponsor I want to talk about is another quasi-sponsor that we have, somebody that you guys know who actually makes these masks, which I have personally used all over the place. I really like the sewing on this one. These are from, that's not the right color though. There's a little bit of a yellow tint to it, but these are from specifically, howdy good sir. These are from Second Wave Masks, and I got to go ahead and help them out with building their website because I'm really excited about this product, and they fit really well. And she just upgraded her whole design to have the little nose thingy that goes right here. So if you're looking for masks and you're looking for actually really, really great masks that fit but aren't too tight, they're just kind of just right, that's this group, Second Wave Masks. Okay, I'm going to put the little thing right here real quick. Is going over hearing questions like we always do. So when somebody wants to go ahead and begin the process of calling in, I'll put up the phone number right now. If you want to call in, we can go ahead and run hearing questions together. Now, usually with you guys, I am particularly light. I'm not aggressive. I kind of go through the basics with you, and I think that's good. What I'm going to be doing is using some of my more odd questions that are specific to unique situations. So I'm going to get to kind of show you guys some of the prototype questions or some of the tricky questions or some of the odd questions today. Because normally we do a lot of the safe questions, and that's fine, that's good, but that doesn't actually do anything for when you get some weird questions. So we're going to be running that. The other thing today that I want to go ahead and do is I want to spend some time here. I'll pull the microphone over here a little better, get some better audio. I want to spend some time going through a basic process for what happens when you are essentially going into a hearing, the emotional landscape, how you can go ahead and build a connection with the judge based upon what it is that you're saying. Now, remember, throughout this whole thing, you will see ghosts behind me moving the mask, the green screen. Those are actually my chubby dogs. So if you're wondering what that is, that would be Layla curling up into a ball. I'm sure where, you know, Shadow is not far behind. He's right over there. All right, so let's go ahead and begin. Howdy, guys. I'm so glad you could join me. I want to talk about the emotional landscape of an individual going into a hearing. I want to talk about, and now she's behind the green screen. I want to talk about something else, which is one of the things I do that a lot of you guys don't know attorneys do. So the first thing that you need to know is that attorneys will not always tell a claimant up front if they have a judge that is likely to do their claim. I had a claimant today where basically, it was one of those situations where I knew the judge was going to try and go ahead and deny the claim. And the reason why the judge was going to go ahead and try and deny the claim is that the claimant had a past history of drug abuse. So I'm just waiting for it to say it's reconnecting because I know it has those issues. Okay. So what do I mean by this? And I just waited for it to reconnect because it's raining outside really bad over here. So I had a claimant. I knew that the claimant was going to get denied. I knew it had to do with, drug history. I knew it had to do with how he had some of his injuries because he was doing hobbies that traditionally a disabled person would not be doing. And, essentially what that equates to is a situation where the poor guy I knew was going to get denied by this judge. Now, I didn't tell him ahead of the hearing, and we won't, as attorneys, tell you ahead of the hearing if we know that will deny you. We'll tell you, hey, look, this is a really good judge. The judge will probably like this claim. These are the types of impairments that the judge likes to approve, things like that. But if there's a judge that really does not like your type of claim, we as attorneys won't tell you ahead of time. And here's why. You might be thinking, well, wait a minute, I want to know. And you're the attorney, and you should be telling me. And you're on my side, so what the heck? Yeah, true. But there's another side of this, okay? So let's talk about that other side real quick. When you are in the hearing, we need a performance from you. And the performance has to be excellent. It has to be one of those situations where we feel like you're just totally and completely on top of your game, and you're totally and completely answering the question in as good and quick a way as you possibly can. If we tell you ahead of time that the judge is likely to deny your claim, there's going to be no emotional connection there. You won't be invested into that hearing. You will have lost all faith in the ability of good testimony on the record as possible. Now, let's talk about the emotional landscape of how this thing works, right? So claimants get highly, highly invested into this situation where they feel like they are de facto, without question, disabled. One thing my claimants rarely ask me, which I wish they would, and they always ask me this way, so they don't ask me the direct question, which is, well, how does it look? How does my claim look? How does it look, right? The problem with that question is they're asking me to basically lie to them, right? Because they're asking me to say, oh, no, it looks fine, it looks great, because I know I have to be nice to them if it's a bad claim to get them to give good testimony in case I have an appealable issue thereafter. So I need them to do a great performance. What did this doctor really say? A lot of you guys will have physicians that don't really actually support, your interaction with the medical system. So, there'll be a situation where the doctor will say, hey, I believe that basically, this person is mild to moderate based. Here's the problem most of you guys run into. A lot of your physicians will go ahead and basically say, well, I feel that they are moderate with this impairment, and this impairment. They might throw some milds in there, but they usually won't commit to the full-on, Okay, so what's a severe or marked impairment? A severe or marked impairment, and they don't really go into as to the statute limitations of how it works this way, but to define it the best way I can in simple terms, like understandable terms, would be based upon the vocational tendencies of how much time per day at a job, right? So out of an 8-hour workday, how much per day you can go ahead and do that thing, right? So if you can never do something at a job, right, that's an extreme impairment. That's the top of the totem pole. You've got extreme, you've got severe, you've got moderate, you've got mild, right? Okay. So what does that mean? You've got that mild, moderate, severe, extreme. So let's say that you go to a job and you've got an 8-hour workday, right? And during the workday, you can't do any lifting over this certain amount. You can't interact with the general public. You can't follow through with basic instructions. You can't do it at all. There's no possible way. And remember, when you're as a claimant, you're like, well, I can't do that. No, I don't mean in that regard where you're like convinced that you can't do that. I mean like an amputee can't do the walking requirements in a timely fashion of what other individuals with 2 legs could do to keep up to do that type of job. It's like a de facto, it absolutely cannot be done. There's no way. It cannot be done. That is a true extreme impairment. I'm really sorry, guys, about the buffering. I know, Christina C., I wish I could fix it. The reality is it's super raining here. I bought my dream home on an island, and it's just the internet's not super duper great. I'm going to actually move this whole setup in front of a big screen TV, and I'm going to have like little bullet points pop up for you guys. That way when I make points, I can see exactly which topic I'm on. So that's why there's some buffering. All right, so let's talk about that real quick. We've got these levels, right, of impairments. We've got these things, right, that essentially are, how we look at how severely impaired you are. Now, the ticket is, if you've got an extreme impairment, you might fall into what's called the CALs, the Compassionate Allowance Listings. All right, so what the heck are these CALs? Curveball Crew, super thank you. Wow, $20. Thanks for the videos. Had phone hearing Friday and was approved at the hearing. Your advice, awesome. I'm super happy for you. That's incredible. Look, guys, if this stuff helps you in any way, that makes me feel incredibly good, because the whole reason I started doing this stuff was because I wanted to help people. I didn't actually want to be, just so you know, a disability attorney. There's a really salty kind of path that to being this attorney. I wanted to be originally. And when you say you wanted to be something, you're like, I wanted to be it because I enjoyed the topic of it, and I enjoyed but you're like, I don't know if I actually wanted it, but you were like pushed into it. That's how I was. I wanted to originally do media law, which is like, film contracts, audio contracts, doing, all that kind of stuff. They want to make a feature film, they want to make an album, whatever. You're the guy that they go to do all the contract stuff. And so, it's one of those gigs, it's one of those deals where I just realized early on that I was in the wrong field of law. So what do I mean by that? I remember going out to dinner, or it was a lunch or whatever, with one of my professors, and I was explaining to him, hey, look, here's the problems that I'm having with my field. Here's the issues that I'm having with this future of being in media law. And at that time, you have to remember, everything was shaking up in the media field. There was no safe ground at all. It was just handed out. Big studios, mega studios were going out of business. Okay, we're talking about the big studios of California with the giant SSL boards and the giant Neve boards and the giant API boards, these big consoles, right? They're all going out of business. And so I started to sit back and I said, howdy, Carrie, how's it going? Dime Darrell, awesome. And I started to realize that I was in the wrong field. I am by trade not an attorney. Well, I mean, I'm an attorney now. I've been an attorney for a long time, but I am by trade actually a music engineer. That's what my real trade. Like, if you want to know about microphones, how to build them, diaphragms in them, what types of microphones there are, all that jazz, what the different curves are, how to get a certain sound, all that stuff, what kind of preamp you should use. I'm that guy. I own some of the rarest microphones in the country, and that's a really cool thing. Some tube, I own them, and I love that stuff. Here's the thing that is, basically one of those structural situations. Yeah, you're right. Let me text her and see where she is. Hold on. Let me see real quick. So here's what you need to basically know. When it comes to the media stuff, I wanted to be one of those types of individuals who would do amazing media law and do these amazing big things and work with these amazing producers and these amazing directors and things like that. It wasn't going to happen. There's no way it was going to happen. So I ended up dating somebody for 2 years whose father was the longest and oldest working Social Security disability attorney. He's still working, actually. He's been doing it now for over 55 years. He's coming up on 60 years of practice. Literally the oldest. I was his first intern around when he was doing his 50 years or whatever. I don't know what it was of practice. So I was his first because I was dating his daughter, and his daughter wanted me to go and basically learn how to do the field of disability law because, to make money, because she wanted to go ahead and have an equine career, basically in the dressage field. All right, so things didn't work out. She found somebody with a 8-pack, 12-pack, whatever it is, those triathlon runners. Really great guy, really amazing. And the bottom line is that didn't work out. However, I went from internship in this field to internship in this field to internship in this field, and so finally, when that judge went up to me and did the wave of the hand, and I said, I agree to follow, we have to go through this whole thing. I designed the, whatchamacallit. I designed basically one of those ideas we use for client management. So let's go back to the whole theory here, because we kind of got off track with that. Claimants believe definitively that they are severely impaired. Some of them even believe that they are extremely impaired. But let's break it down into that system. 8-hour workday, right? Which is easy to think about. It's not perfect for breaking up in thirds and stuff like that in the brain when you go right to it. But let's just use it for right now and make it simple. If you absolutely cannot do anything, right? You cannot do that function. That is an extreme limitation. Right? So let's say that you can't do some walking functional. A lot of you guys, you've got a walker or a wheelchair or, a 4-prong or a 1-prong cane or whatever. You've got this stuff, which is really, really good. But the reality is this, okay? Most of you are not to that extreme level. If you've got a cane and you're having a little bit of difficulty here and there and you sometimes use it to walk, that's more along the lines of moderate. If you've got a walker that you need to use all the time that has a seat which you have to sit down on all the time, then in that particular instance, what that equates to is a moderate to severe, possibly severe impairment. That's kind of how these guys start to think about it. Now, if this is a situation where you are stuck in a wheelchair and unable to use most function of the body, that's in the severe to extreme category for basically just understanding extreme means you can't do it at all. The next one is the severe. That means you could do it from 0 to 1/3 of the time area. That's usually how these guys tend to look at this thing. 0 to 1/3 of the time, that 8-hour period, right? And then you have the moderate, which is like 1/3 of the time to 2/3 of the time, you can basically do that function. And then 2/3 of the time to doing it all the time is like a mild impairment. And then no impairment at all is basically where you can do it, you know, without issue, right? No impairment means no issue, means no restriction of time, right? So these are the structured levels as to how they think of this stuff vocationally. And it's important to think about it that way, because when they look at a job that you could potentially do, the problem is, at the end of the day, you know, these situations, right, these interactions, these problems that people have, they've got to categorize it. A lot of people think close. That's not even the whole shebang. The way it really works for most people is through a vocational allowance. They go through all 5 elements, and then if they can prove and show that they're unable to work in the national economy, then at that point, cool, they'll be found disabled. All right, so I want to talk quickly about the emotional walking into that hearing moment. A lot of people walk into that hearing room. Now, right now, it's all telephonic, so it's a little bit different. Well, you're right. You know what? Let's start with the telephonic thing, and then I'll go into what it's like to walk into the hearing room so you guys have a better understanding. So, do judges ever send claimants to take a drug test? That's happened once before in doing this for, I don't know, 10 or 11 or 12 years with my firm and other firms. Yes, it does happen, which they can do. Yes, it does happen, which they can do that as part of a and obviously they're not going to do it unless it's one of the situations where they don't have it in their system. Now, remember, most of these situations where they get people with drugs in their system, it's where the person has an emergency and they've got to go to the hospital right then and there. They'll hit them with the UA, a urine analysis, or a blood test, a BT. So with the UA or BT, it's a situation where they'll find it in their system. And the reason they find it in their system is because the person hasn't had a chance to hide it, right? Because they're in there for an emergency. They got something broke their hand, something broke their foot, something happened. They had a mental breakdown. They want to commit suicide. That's what happened. So, all right. So let's talk about this for a moment. The emotion, right? The emotion of basically interacting with the judge. I can spin down. Interacting with the judge is that most claimants walk in there, or let's do the telephonic thing. Most claimants answer the phone. Right off the bat, there's a lot of people breathing on that line. You can hear people breathing in the phone, right? For their hearing. That's the vocational expert. That's the attorney. That's the judge. You can hear people breathing. It's not perfect silence. People have things going on. So you can kind of tell it's one of those situations where they, you know, people, the claimant starts to tune in and realize it's happening. This is the moment. This is 2 years, 3 years. I've been waiting for this. This is the moment. And then they go through this is the moment thing. And then they start to realize, okay. And in my claimants, I tell them always the same thing, which is, remember, you just have to tell the truth, be aware of what the overall thing is, you explain why you have a difficult time working, and be able to know what are your top 5 impairments thing is, you explain why you have a difficult time working, and be able to know what are your top 5 impairments when you know this ahead of time. My claimants know this ahead of time. All right. So they answer the phone. Their brain immediately goes into go mode. Don't talk too fast, but talk fast. Yes, 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 yes. They're answering quickly. They're trying to get their bearings. They're trying to figure out how this is working. Yes, 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 yes. They're answering quickly. They're trying to get their bearings. They're trying to figure out how this is working. Now, pro tip for you guys. The judges, they don't do many sentences. They're all like sentences with little sentences attached to sentences. So don't be that claimant that's like jumping and going, yes, 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 Your Honor. Yes, I agree. Yes, Your Honor. Yes, Your Honor. Wait for the judge to give you a moment to enter and say, because the judge will say, okay, I'm going to go ahead and do, Wait for the moment. where the judge is waiting for you or expecting you to actually talk. Don't jump in, because it's one of those things where all we hear on the phone in the very beginning is the judge talking and you going, yes, 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 yes. And the judge is still talking and all we hear is this. So don't like, let's see. Okay, so basically what that means is that it's a situation where, and I just waited for the thing to come back. It's a situation where you have to talk in the very beginning for a few things. Number one, you have to validate that you are who you are. So they're going to ask you your name. Are you in a room by yourself, and are you not recording, right? Because there's only allowed to be one recording, and that's the judge's recording. It's really just the judge's clerk. The next thing that you need to know is that the judge is going to do the affirmation. You know, do you swear to tell the truth, the whole truth, nothing but the truth, yada, yada, yada. Those are moments where you're expected to talk. But when the judge is just telling you stuff, you don't have to be like, oh, yeah, sure, cool, awesome, I got it. You don't have to do that stuff. Okay, so next thing. Let's go ahead again. Let's see. Back in 2010 at my hearing, the judge just asked the VE. All right, so Dime Darrell, I'm reading yours. Back in 2010 at my hearing, the judge just asked the VE, was there any jobs I could work in the national economy? And she said no. That was it. My lawyer told me after the hearing I won the case. Yes. So basically, if there's no jobs available in the national economy and you can't do the past relevant work that you did, which is those are the jobs that you did within the past 15 years, then you're set. You're good, because there's no jobs out there in the DOT that they can pin on your shoulder, which basically means you're good to go. All right, so let's talk about this. After the claimant goes through that super excited, that super hyper moment, that moment where they're just super into this, the claimants, they always get into this like, oh God, it's starting to happen mode. After about 10 questions, they get out of that low mode. That low mode is where their brain is starting to take over and telling them what they should be doing, what they shouldn't be doing, or yada, yada, yada. They get into this low mode. They are fearful during the initial questions to go ahead and answer things that the judge will ask. And the reason why is because they know what the judge is looking for if their attorney properly prepared them. A lot of you guys, you know, if you had a bad attorney or the attorney didn't prep you, you were just winging it. But most of my guys, they know they've got to explain why they can't do work. And every category of something that's brought up is in relation to being able to work. So for example, it's a situation of like, you know, if they are asking you about laundry questions, if they're asking you about, you know, doing outside yard work questions or cooking questions or buying groceries, you answer them from the perspective of describing them as to why you cannot work, why you cannot do groceries. Because if you're talking about getting groceries, they want to know why you can't be a stalker. They want to know why you can't be a price checker. They want to know why you couldn't be a person that puts prices on items. So it's always got to be from the perspective of why you can't do that job. All right. So first 10 to 15 questions, claimants are always in scared low. Unless they have no idea what's going on, then they just wing it. They just wing it and usually come out with the dumbest things I've ever heard. And that's scary as hell for me, because then I can't always fix everything. All right, so let me ask you this. All right, so let's say when it comes to basically getting to that next 15 questions, right? So you get past the first 10 to 15 questions, then you get to the next lump. At that point, the claimant is doing what I call settling into their chair or settling into their seat. So what it means is that basically when they settle into, they're happening, yada, yada, yada. So that's good. So then we get through another 15 questions. Now, judges will usually, and I want to tell you guys this ahead of time, judges will usually bring out the tough questions. I'm talking about bring out all the easy questions up front, right? They'll bring out all the easy questions right in the beginning and sort of into the middle. But then after that middle point, right, the middle to the end point, that's where they bring out the killers. That's where they bring out the tough questions, the questions about drugs, the questions about alcohol, the questions about tobacco-related products, the questions about why you were in a penal situation. And remember, some judges are not going to approve you. Super thank you. Another $20. This is like, whoa, this is super cool. This is amazing. I thank you for your time, sir. Thank you for your time. Thank you for making this channel amazing and helping people with that. So that's super cool. Yeah, this is amazing. So basically what you have to know is this. And I want to point this out, caffeine addict. Some of you guys have caffeine problems and they're so severe. And about 2 months ago, I had a claimant that was actually part of the consideration as to whether caffeine was causing her cardiovascular issues. And during the hearing, and I didn't think of this because this was new. I didn't know what was going on when it happened. Brought out basically that because of that type of impairment, it could be brought on for caffeine. And because of the tests that claimant had, and I just didn't connect the dots, one of the major causes was caffeine. So instead of having questions about like how many beers you drink, we actually had questions about how many coffees she would drink, what kind of cigarettes she was smoking, and then what she would do, and all these things. And caffeine was actually treated as something that was like almost like a narcotic, because it was something that was causing her impairments. And that was new for me. I'd never seen like, the addiction base for coffee. So when I just want to remind you guys, when I saw a caffeine addict, that's what that is. They actually brought it up in a really unique and interesting way. And this was not like your Starbucks person that's drinking high-end coffee and yada yada. This is just somebody who would buy coffee in bulk, like a BJ's or whatever, and they would buy tons and tons and tons. Built up in their system, which gave them cardiovascular issues, which gave them pumping problems, which gave them all these problems that they were claiming limited their ability to work. So the cool thing is that the judge actually used that in their assessment for weight as to whether or not that caffeine was material in causing their impairment, because caffeine is an addiction. It is for a lot of people. A lot of people have to have a certain soda. A lot of people have to have a certain coffee. A lot of people have to have a certain whatever. They got rid of a lot of those energy drinks where they would mix alcohol and caffeine because they're killing people. All right, so let's go back to the tough questions. So in the middle to the middle end, so let's see, Nikki McDonald, I won't accept for sure until I get it in writing. My attorney says I'm for sure, but I've heard that story before. I had a hearing on 521. That message, 527, judge cut her off questioning me. Oh, okay. So here's the thing. When a judge cuts you off, like if they cut off the attorney, that's it, or just want to deny it, they'll cut off the attorney. That's just what they do. If the judge is like, I don't know, we're buffering again. About the buffering. So basically, when a judge cuts a claimant off, that's usually because the judge just wants to find the claimant disabled. That's usually what that means. It's almost always like that. So when a judge wants to find a claimant disabled, the judge will just be like, okay, let me ask you a question. Let me ask you a question. Let me ask you a question. And then when the judge is done asking those questions, they'll have the attorney ask questions, the cross-examination. And then at that point, if the judge cuts the claimant off while the claimant's talking, that is a signal to the attorney to say, attorney, shut the bleep up. I want to just approve this. Lunch is in 15 minutes, and I must be in my car in 10 minutes. Right? That's what that means. So, Nikki, that's probably a good thing. That's actually a very good thing. So, if the attorney brings a bunch of questions, the judge wants to go to lunch, let's get her done. That's what it is. Okay. So, so here's the thing. When the judge goes ahead, and I'm just waiting for the connection to come back. Whatchamacallit? Okay, so when the judge goes ahead and cuts off the attorney, that can mean two things. That can mean two very different things. When the judge cuts off the attorney, it means that there's very likely a problem. What do I mean by that? So today, actually, the judge cut me off and said, counselor, I don't want to hear, if you have additional questions, yada, yada. So what that means is that the judge is either saying, I just want to deny this, stop screwing around, yada, yada. Let's just get her done. I want to deny it. We're moving. What that could mean. It could, Nikki, let me ask you this. When the judge cut off the attorney, did the judge make a quick little phrase thereafter about, your age? Or, for example, like, we've already heard testimony about this or anything like that? So I'll wait for you to pop in and put the thing. Let me see. Carrie said, I had my hearing and my attorney didn't ask the VE any questions, stating he didn't need to. Sometimes the attorney doesn't actually need to ask questions to the vocational expert. It's rare. I had one of those today where there was no point in asking questions to the vocational expert. With that said, that is a 1 out of 30 to 1 out of 50 situations. He moved to the medical expert. Yeah, but before he moved, Nikki, before he moved from the attorney to the medical expert, did he make any comment? Communication that happened between the attorney and judge. All right. So what that usually means is that it's a situation where, now, Nikki, let me ask you this: was your claim running late? Like, did you start an hour late or anything like that? What's it? Okay, so top hat. What's it mean when a person's attorney wants to advance a client's age by 8 months to place them from 54 age category to 55 category? It means they're wiping out all of your back pay. They're using the nuke rule, top hat. And what they're doing is they're trying to basically get you into a higher age group gridding. If you're not sure what griddings are, look up grids. And it's basically like an Excel sheet. It's a statute, but it's like an Excel sheet. The older you are, the less education you have, the simpler likely you'll be stable. So that's what he's doing. He's trying to get your claim through. He's wiping out your back pay. And what it's called is it's called a non-mechanical application allowance. And it's where the attorney negotiates with the judge to get you moved into a higher age group. And in doing so, usually they'll wipe out a lot of your back pay. Now, it could be a gig where they're just moving your alleged onset date, where you filed before you were 55, and now, you're 56 or whatever, and they're just moving the alleged onset date to when you were 55 to get the gridding allowance to 56. It could be that you're not 55 yet, right? And they're trying to just snooker it through. But then you run into the problem of, is your impairment severe under the code? Because remember, a severe impairment requires 12 months. Okay, let's see. Carolina, these attorneys know the likelihood of being approved or not, and sometimes do not need to cross-examine the VE. Give a listing. Wait a minute. So, Nikki, when you say the medical expert, was the medical expert present at your hearing? Because medical experts present at a hearing is super duper rare. You'll usually have a clerk, a vocational expert, the judge, you, and your attorney. So that's super duper rare. So walk me through this, Nikki. Was a medical expert present? Okay, cool. All right, so that changes everything. Changes everything. Everything's a little different now. Everything's sparkling. All right, what that means is that now normally they ask the medical expert in the beginning before you even give testimony where they stand on it. And the reason why is the judge uses that to just basically say, okay, if the medical expert comes in after you give testimony, then what the judge is trying to do, and this is the simplest way I can put it. If the medical expert comes in after you give testimony and the judge cuts your attorney off, then the judge is trying to approve the claim. And the reason the judge is trying to approve the claim is that the judge is just looking for the medical expert. And trust me, the medical expert that's sitting in that room knows what the judge wants. If you're thinking, it's neutral, blah, 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 blah. When the judge does that to that attorney, the medical expert knows I better give a good reflection here that the claimant is impaired because she's pushing up that tree, and that's what that judge wants. Okay, so all right, so let's see. Then talk for 25 minutes. Yeah, so if the medical expert said in combination, totality of circumstances, that all of your impairments meet, equal, or exceed the requirements of the listing, then you're able. Okay, I can't promise anything because I didn't read your claim. I wasn't in the hearing, blah, blah, blah. But that's basically what's going on. Okay, excellent. All right, so let's see. People need more positive people out there like you. Blah, blah. Good. Do combat PTSD claims often get approved by a listing? So here's the thing with combat-based PTSD listings. They do often automatically get an approval because they have 100% VPAT rating from the VA backing it. Maybe the PTSD isn't the full 100, right? Maybe it's just 40% or whatever. But in totality, you're not working. You've got 100% VA allowance, at that point, or VA rating rather. So yeah, a combat-based PTSD claims, they even have their own expedited statute allowance, which I think is I-2-1-40 subsection A2. So in that regard, yeah, those usually through. However, the best evidence you can have for that type of situation is 100% VPAT allowance via the VA. Okay. And ME did, the judge gave no hypotheticals to VE. Okay. So yeah, Nikki, if the vocational expert wasn't given any, all right. So what that means is that the judge is just going to give you a step 3 listing allowance. That's what it means. or the judge will just give you what's called a vocational allowance, which means that the judge didn't even need to reference, because remember, vocational experts for administrative law judges are options. They are not required. A lot of people think that vocational expert is required to be in that hearing. No. They're just optional for the judges to use as part of their adjudication. A lot of the old judges, the judges in their 70s going on 80s, they won't even use a vocational expert, because back in the day, 20 years ago, 30 years ago, vocational experts were not part of every single hearing. It just wasn't, it wasn't how they did things. Things have evolved a lot with how hearings happen. Hearings nowadays are totally and completely different. So that's one of those gigs where, you know, it's one of those situations where basically the hearings nowadays are just very structurally different than how they were 30 years ago. Okay, so talking stuff. I want to do a call, if that's cool with you guys, if somebody calls in. And basically, then after that, what I want to do is I want to read for you what an actual opening statement sounds like. It's like an opening statement / brief. I want to read for you essentially what this all comes out to be. So after we do a phone call, or actually what I can do is this. I have a claim coming in, and I know a lot of you guys don't know what briefs are like for attorneys. So I actually brought a brief. I can't show you it because it has names, you know, it has like plaintiff, defendant, all that stuff on it. So I wanted to go ahead and read for you what an actual brief / opening statement, because a lot of the ones I'm doing right now are brief / opening statements. They're really long opening statements that are really just briefs. And then when they ask me, hey, do I want to give an opening statement? I say yes, and I give a summary of it. Or I say, no, I'd like the opening statement that I've submitted into the record to stand, and I waive my right to an oral opening statement. So if it's okay with you guys, before the person calls in, which I think was T. Valera, which is a really cool name, I want to go ahead and basically read for you guys this opening brief. So an opening statement / brief, so that you understand kind of what it's like. Title 16 and Title 2 SSDI claim for benefits before the Office of Hearing Operations, right? So that's essentially the opening, right? That's the beginning. I'm explaining in the very beginning that it's Title 2, Title 16 based SSI. This is a memorandum in support of the claimant being found disabled. It's for the OHO, which is the hearing office. And here we go. Hold on to your seats because a lot of this is not going to make sense to you. Just relax. I'll break it down after I read through it. Your Honor, I wanted to thank you for your continued service to the American people during the virus outbreak. Please stay safe and healthy. The 3/22/19 Notice of Award letter for SSI dictates this remand review will encompass a potential SSI period from 2/15/14 to 3/21/19. Since the DLI is 0611 and there are no new earnings via the detailed summary or new hire, we are requesting withdrawal of the T2 claim. Additionally, please amend the AOD to 9/2/14 as this writing will shows a time under adjudication. We're requesting, I see the connection went down. Connection's back up. Cool. We are requesting that the SSI claim be added back to the ERE for adjudication purposes. There's no indication in the record as to why it was removed. You will notice that the original 7/12/17 ALJ unfavorable letter on page 16 notes that the T16 claim was adjudicated as a part of the original judgment. Please also take note of the 16A Fed Middle District complaint during the Section 1, Paragraph 1 notation as to the SSI benefits being included throughout the appellate process. I know this is above a lot of people. I get it. But just stick with me. I'm going to read the rest of it. That's the first paragraph. We're almost done with it. We have one more big paragraph and then a little itty-bitty paragraph. Your Honor, this remand occurred due to cleaner housekeeping being included in the available Step 4 PRW without necessary specificity of physical requirements or demands. All on page 11 notes severe primary dysfunction of major joints and secondary severe affective disorders. Please also note that the 10D summary earnings shows SGA up to 2006, with questionable SGA in 2005 and 2007, which via the 17A District Court remand decision explains their concern over the specificity as defined in the 2017 unfavorable decision for SGA-based housekeeping limitations. The top 5 impairments for this claimant are anxiety / panic attacks, depression / bipolar, joint dysfunction, carpal tunnel syndrome, and chronic homelessness. The date of birth equals 9/20, I'm not going to say that, which at the application date, PFD makes the claimant 50 years, 4 months, and 18 days On the day before she was found disabled in 2019, the claimant will have been 55 years, 5 months, and 24 days. Please consider the following AOD anchor points, which help solidify 14 AOD. Below sedentary, Dr. Bleep, RFC. 5F page 47164E, CE notes depression, anxiety, emphysema, carpal tunnel, hands, scared, headaches, bladder problems. 6F page 4, 72214, CE notes COPD, bursitis of the hips, bipolar, incontinence. 3F page 65414, ORMC, epigastric pain, COPD, bipolar, fatty liver, constipation, rest for cocaine. 7F page 2, 9214, Dr. Torres, MD, less than 5 pound lifting limit, markedly limited categories. 9F page 5, 11614, OB, it's the medical facility, 51-year-old female not being able to hold her urine, always urinating on herself. Your Honor, this is most likely a grading or vocational allowance based upon the PRW, age, and SVPs. Your Honor, as always, it is an opportunity to present this claim before the Social Security Administration. For that, we thank you. Now, look, you're too complicated for the average person to understand what's going on. And the reason why is that this is actually a very complex area of law. A lot of people think like personal injury or business law are complex, areas of law. Business law and personal injury are kind of like the bottom. It's the most basic fundamental thing that we learn as attorneys, right? Business law is mostly, for the most part, it's contract law, property law, things like that. Personal injury is, as it is, personal injury, slip and fall, car accident, stuff like that. Disability law is actually much more tricky because you have to learn this whole different set of laws. Now, it does not require a postdoctorate specialty to practice it, like tax law or maritime law. But it's the thing that's right below the severity of doing those two types of law. And this is basically one of those situations where it is quite complicated. I'm going to do a real quick summary as to it, and then let's do the phone call. Your Honor, I want to thank you for your continued service, blah, blah, blah. Stay healthy, right? COVID notice. 322 notice of award letter for SSI dictates that this remand review will encompass a potential SSI period from, all right, I'm talking about a closed period of review. Most people think that when you apply and that, you go to your hearing, it's just an ongoing thing, right? Sometimes claims have closed periods. We're only requesting a finding of disability for this closed period. Pretty neat, right? All right, next thing. Since the DLI, date last insured, is 0611, right? And we're talking about a 2014 starting claim here. Since the DLI is 0611 and there are no new earnings via the detailed summary or new hire. All right, so what's a detailed summary and new hire? If you aren't part of the disability law field, you would not know, but the IRS submits to the SSA. They show us different things. What do they show us? The summary earnings query goes through year by year and tells us how much you earned per year. Simple, very simple one-pager. The detailed earnings query shows us which job you worked at by year, what you earned at that job, and what you earned in total in that year, right? The new hire query shows us what quarter in the recent years you worked and earned money, okay? That way we know if there's any recent earnings that could affect your ability to receive disability benefits, because element one of this whole thing is, are you earning SGA, $1,260 per year? And if you are, you're not disabled. So let's go through this real quick. So additionally, let's go back to that. So let's go through this real quick. So additionally, let's go back to that. The SSDI benefits, it's not going to work. We can only go 7 months back in time from the moment that claimant files, which puts us into, basically the 2012 area potentially. I think it was actually early 2013 because it's pretty far forward into 2014. That actually tells us, right, that we can attach to a date far enough back in time for the disability insurance program, SSDI. Now, that's a super complex thing, but just remember this. With date last insured, that's the last moment in time. We got a timeline, boop, there's the moment. Date last insured. It's the last moment that we can claim, or before that we were severely disabled and still insured to go on the better disability program. If we have to application allowance, then basically it's not going to go ahead. And, in that situation, we'd ask for a non-mechanical application where they just go back a day. But let's say that if you were 5 months after that, right, we could still probably get a non-mechanical time, and we can't attach to that date last insured, we got a problem, because then we can't go on to SSDI. All right, let's see. A question. I received my bonus check from prior year or current year. Oh, no, on current year. Despite not working a day since late 2018, would the IRS give the SSDI perception that I was working? All right. This is actually an incredibly complex question. The bonus check. Was this part of some program? Was this a traditional bonus check? The other thing I need to know is this. Let's say that you got this bonus check and it was like a classic bonus check. I don't know why you get it a whole different year later, which is why in my head it's ringing bells going, wait a minute, there's something wrong here. So the bottom line is, okay, let's say that you get this bonus check and it's a classic one, right? You worked, you did a good job, they're going to give you a bonus check, and it's the next year. That is usually what's considered countable income. Now, this is going to get super bogged down in the mud, but there's two things you need to know about it. There are countable resources in the sense of income and assets. Income is stuff that you earn that month, and assets left over that wasn't income anymore. So if you earn something in month 1 and you don't spend it to get rid of it, by month 2, it's one of those gigs. Oh, sorry, we just went into a buffering thing. So if you get something in month 1, right, and it's income, by month 2, if you haven't spent it, it becomes an asset, right? So now it's no longer income, now it's an asset. There are countable assets and countable income. There are countable assets and countable income. There's also not countable assets and not countable income. Doing a whole thing on that will take forever, but the bottom line is, in that case, that's going to count. However, it's only going to count, and I'm assuming it was a larger amount. Like, we're not talking about like $500, right? We're talking about like $4,000, $5,000, $6,000, $7,000, whatever. We're talking about a chunk. With bonuses, the way that judges usually handle it is that for that month, you are not considered disabled. Sounds weird, right? Just 1 month, it's like a little island on the big string. For that 1 month, you are not considered disabled. And the judges really don't pay it a lot of attention. They don't pay it a lot of mind, as people put it. Because here's the tricky thing about it. Judges care about you working and earning, right? Because they're looking at SVPs. They're looking to see if you were still working, then it screws up element 1. But they don't really care about, you got a bonus in 1 month, it's a chunk of money, yada, yada. Now, they're going to care if it's a lot of money. If it's $100,000 and you're looking, and you're saying, I got to go on SSI, then they're saying, whoa, that violates the 2K rule. Rule. You can only have $2,000 bank account. Judges, it doesn't even come into their work. For SSI, it does, because they're looking at the $2,000 rule. You can't have more than $2,000 in the bank account. So, okay, when you say more, okay, so SRT. So, okay, so we were buffering there. SRT, when you say more, and this is only for SSDI, right? You only apply for SSDI, right? So only SSDI. Let me know in the comments. Are we talking only SSDI? Yes? No? Okay, if it's only for SSDI, it's not a big deal. Now, when you say more, what are we talking about here? Are we talking about a lot of money? We're talking about a little bit of money, because it's not going to hurt you for SSDI benefits. You can win the lottery 1 month and not be eligible. Okay, 13K. All right, so that's not bad. That's not a big deal. Sometimes you guys will be like, all right, so I had a person die and I inherited, 500. Somebody, there's an inheritance and it's like, 1.2 million. I'm like, okay, well, the questions that are going to be coming. Well, hey, why don't you have insurance when you claim you weren't able to go to the doctor? Dime Daryl's right. I'm sorry. I totally went off on tangent. T. Valera, if you want to give me a call, now would be a good time, and I'll go ahead and run hearing questions. Okay, so let's see. Hold on. I'm just responding to people who texted me. Okay. And okay, so question. Recently denied hired lawyer for reconsideration appeal. The medical evidence suggests that you have fibro, depression, anxiety. First of all, fibro claims are difficult to get through at the initial filing or the reconsideration level. So you're almost always going to have to go in front of a judge for fibromyalgia. So just keep in mind, I'll type it out. Let me put this number in here, 47279-1754. Okay, sorry for the buffering. Again, it's because the internet's wet out there. Sorry about the buffering. It's because the internet's wet out there. For fibro claims, you almost always have to go in front of a judge. So you're going to get an initial denial, you're going to get a reconsideration denial, and then you're going to have to go in front of an administrative law judge. That's the deal with fibros. Anxiety and depression actually have heightened standards that you did? Did you call the right number? Let me see. Is it the 407-279-1754? Try calling it again. And I will sit here with the phone like this. So your particular types of impairments make it more difficult to go ahead and be found disabled. So when you said, hey, I got fibro, I got depression, I got anxiety, you know, your fibro, it's almost always going to have to go to, so the number is, here you go. So you're almost always going to have to go in front of a judge. And remember, depression and anxiety, they changed the statute requirements. So it's a situation where you're pretty much, you have to show severe to extreme limitations with those. And here's what they're looking for with mental impairments in general, like a general landscape thing. They expect you for 2 weeks of every 4 months to be seeking treatment, having treatment, and that treatment to be showing that you're severe. They're looking for Baker Acts. They're looking for heavy mental medication that's treating you for the fibro, or a mental specialist for the anxiety or depression. That's important too. So if you have a chronic condition with fibromyalgia claim, is it easier? Look, guys, so here's the deal. Fibromyalgia claims are never easy claims. In fact, I had a judge explain to me one time, he's like, look, if you're going to be bringing that crap in here, and it was mostly a fibro claim, but he's like, look, if you're going to be bringing that crap in here, I want to see this, this, and this. And the problem was it was a homeless person, and I'm sitting there going, okay, you know, because remember, the judges tell me, oh, I got to answer this. Okay. Hi, this is Attorney Walter Hnot. Are you ready to go ahead and run some hearing questions?
Yes.
Okay, perfect. So one thing you want to do is go ahead and mute your computer, and also you've got to use a fake name. So what fake name would you like to use for this?
Mary.
Perfect, Mary. Now, if you don't give me a last name, it means I get to make one up, and it's probably going to be Poppins. So what kind of last name would you like?
Yeah, Poppins is good.
Perfect. Perfect. I'm so glad. That's gonna be amazing. All right, I'm gonna switch the microphone over here. We're gonna go ahead and line up the phone. Let's go ahead and begin.
I can see you, but I can't hear you anymore. Do you want me to mute you?
Can you hear me through the phone?
I can hear you through the phone, yes.
Yes, that's perfect. Go ahead and if I'm muted on the computer, that's fine because we're real time, and otherwise there's like a 3 or 4 second delay.
Okay.
All right. So Mary Poppins, away from everybody. Are you recording this?
No.
Excellent. Let's go ahead and begin. Now tell me this: are you left or right-handed? Okay. What's your date of birth? And make a fake one. And your current age. Make a fake one.
Oh, 9/7/60. Birth date, and what was the other question?
Just make up a fake age, something that's around your current age.
57.
Okay, perfect. So we're 57 years old. Excellent. So yeah, I know that's Cheyenne's right, 62. So let's go ahead and go through this real quick. Madame, can you tell me what are your top 5 most severe impairments?
COPD.
Mm-hmm.
I have neuropathy,
Mm-hmm.
which is the worst part of it all, really.
Mm-hmm.
Hashimoto's does tend to leave you quite, weak, and it takes a lot out of you because it's attacking your thyroid. I don't know if you know what that is.
Mm-hmm.
When my doctor first said it to me, I thought it was a joke. I didn't even know what he meant. But Of course, leading from all of this, I was a real estate management. I ran construction sites for over 5 years, and I've been a realtor for 20. And I did get SSI. However, what happened was, this is my main point, is that he chose to go back to my 55th birthday as opposed to my 53rd birthday. However, he made a mistake and did it to my 54th. So, when I called my attorneys back and said, hey, look, what's going on here? He was trying to make it so that I wasn't fully vested. So I called Social Security, which we all know, they all tell you a million different things that are definitely not true, because I don't think anyone there knows really what they're talking about.
Yeah.
But, after you wait for an hour on the phone, one person will tell you one thing and blah, blah, blah. However, I did find out that I was fully vested when I became disabled, which means I was entitled. One point in my life, I did make quite a bit of money. I've been more than 15 years old. So, that being said, I know it goes by, they, chart it by terms of some type, 10-year terms or whatever it may be. But I did call them and confirm with them that I was fully vested at the time of my disability. However, the judge did what he wanted to do. He offered to me on my first conference with him. I said, that's unfair. I think I pissed him off or whatever because I did not accept it. However, when he finally gave it to me, he gave me SSI, which I should have gotten SSDI, and, worried if you piss him off, so to speak, the judicial law. That's it, when I was disabled. And I got, of course, now mental problems. I mean, I have anxiety that's like off the roof. I'm not going to say I'm a depressed person because I'm really not. I'm losing off the roof. I'm not going to say I'm a depressed person because I'm really not. I'm losing my home. I mean, I can go on and on. But I have COPD. The neuropathy is the worst because neuropathy all through your legs, you cannot stand. You cannot stand for any period of time. And a lot of jobs require you to stand. I cannot even cook a meal. I have got to sit in a stool if I want to cook for me and my kids. So, I mean, why can I fight for what's rightfully mine? I only make $800 a month. I'm losing my home.
All month.
On disability because of the...
Okay. What was your date last insured? I'm assuming it was somewhere in 2013.
No, I was fully insured in 2014 when I became disabled.
Well, in 2014, you became disabled for SSI, but you're saying that he did not vest SSDI because it sounds like your date last insured was farther back than your 54th birthday, which was a mistake by the judge because he was trying to grid you out at 55.
That's correct. But
Okay.
he made a mistake there too because I was only 54.
Okay. Do you know what your date last insured was?
I did call Social Security and I was insured at the onset of my disability. I will tell you that.
During 2014?
My point is that, I mean, at least even a couple $100 more a month would make a difference for me, at this point in my life. I don't know how I can live for the rest of my life like this. So, but my lawyers are like, we need to go private. And I'm like, why? Why are we not? She just wanted to get up to the attorney. We can turn with it, you can lose all your benefits, blah, 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 blah. I mean, is that true?
Okay, so real quick, did you hire an attorney? And this is what's happening. I'm just going to tell you what's happening behind the curtain. You didn't hire an attorney that is registered with the federal court system to do higher level appellate law. That's basically it. So you've got an attorney. They've got the pitchfork again.
He's a better known attorney in this area.
Yeah.
So I thought I would go with them, However, when it got settled, after I had to go on welfare to hold me over, which was forget about it. What they give you, you don't want to know.
Mm-hmm.
Not was it supplemental income, whatever it was. I don't know, which is actually after that. But I had to pay them all back. I had to pay them back. I had to pay the attorneys, and after that all got paid back. Guess what I got? $190.
Woo! Big money. Which are you
Yeah.
getting, the yellow Lamborghini or the red one? Understand. So what can you tell me, what was the exact date back in time that you were found disabled?
Okay.
Your back date.
Okay. It was 2014, and it was around the month of I have to say July.
July. Okay, cool. So okay,
And
so
I felt it come on like it was. I was actually at a party for some of my co-worker was recovering me.
Mhm.
And out of nowhere, I just started feeling like not myself. And I guess it's when Hashi kicked in.
Yeah.
But from Hashi,
Real quick, I want to redirect. 7/14 is when he found you disabled from.
No, he wanted to move me to my 55th birthday.
Right, but he found you at
When I was only
54. So what was the actual date he found you disabled from?
I was age 53 when I became disabled.
Well, but
he
that
wanted
doesn't
to
matter.
move it to-
What was the date he found you disabled from?
Oh dear, I had to pull the papers, but
Okay, so here's what I'm getting at. You haven't realized yet why your attorney doesn't want to do this, and it's because he gave you SSI benefits, right? So we got that. We know that. But he didn't
Yes.
give you SSDI benefits, right?
correct.
So then what's insured?
When I hear at that age, and she said yes.
Obviously, you were not. And I hate to be the bearer of bad news, but if you don't know what your date last insured is, your date last insured was likely after that point. Otherwise, if you were found disabled for SSI, you're almost certain to be found disabled for SSDI as well, so long as your date last insured was after 7/2014. Do you have your letter, the unfavorable letter, or the fully favorable letter? Or no, actually be a partially favorable letter.
Yeah. Yes, yes, I do.
Okay, do you have it with you? Can you get it out? This information to be able to help you. I mean, we can run questions, that's fine, but if you want to know why this isn't going to work or why it's going to work or what you can do to make it work, like I can tell you, you just find that. Like, is it easy to find or not really?
It's right in my hand. Like, give me a minute, because my file's right here.
Cool.
I keep thinking,
Find
I'm a very
it.
organized person.
Good. So
okay, here's my.
Yeah. So here's what I would say. Find the partially favorable. Once you find it, then we'll go ahead and keep rolling. So guys, we're going to give her a chance to go ahead and find that partially favorable.
I'm sorry, I don't want to hold you up.
No, it's okay. Take a moment.
It should be right here. Thank you for using.
Just scroll. But before the exhibit list, before they put all those little exhibits, so go to the very last, like where they had paragraphs page.
The very last page. Well, it's a long thing right now. Like.
Okay, but go to the very end. It'll have like a summary section at the very end. And what we'll say is the claimant protectively filed, blah, 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 blah. And what we're looking for is where it talks about supplemental security income and Social Security disability insurance. It's like literally the last paragraphs of this whole thing.
Okay, it says the component of responsible for authorizing supplemental security income will advise the claimant regarding the non-disability requirements for those payments and if eligible the amount and the months of which payment will be made. That's what it says. Based on the application for SSI, particularly filed on February 24th, 2015, because I had to get a lawyer. I'd say.
Okay, so wait. That's really important. Let me get a sticky note out because I forgot to bring a damn pen with me. All right, so what was that date again? Based upon SSI protectively filed on, what was it again?
Oh my gosh.
You were just reading it.
I know. It says the Social Security Act, he was trying to refer back to my 55th birthday, which I was only 54 in that at that time frame.
Wait, wait, keep reading it though, because you're giving me a spiel that's wrong. I need to know exactly what it says, because this is key to this whole thing. Yeah.
Okay. Based on the application for supplemental security income protectively filed on February 24th, 2015, the claimant has been disabled under Section 4614A 3A of the Social Security Act beginning on September 5th, 2015. The component of the Social Security Administration responsible for authorizing supplemental security income will advise the claimant regarding the non-disability requirements for these payments. Years.
Read for me, because that was the mini paragraph for SSI. There should also be a mini paragraph there for SSDI. Do you see one that talks about Social Security Disability Insurance? It's basically like Social Security Disability Insurance protectively filed on boopity boop.
No. Right. I am fully disabled. I can't even cook a meal. I mean.
Okay, well, that's off topic though. Do you see a paragraph that talks about Social Security Disability Insurance right above or below the SSI paragraph?
No.
All right, so here's the deal. Your attorney
fucked up.
Massively. No, I know. I was going to say it too, so it is what it is. But they screwed up in a tyrannosaurus. I don't know how that makes sense, but that's in my head what I'm imagining.
It makes sense.
You were not filed for both programs at the time of your hearing. Any writing that was submitted to the SSA to join SSDI benefits into your claim so that you had a concurrent filing. Did anybody at any point say, oh my God. Oof, ugh. All right. So, God.
How can I live the rest of my life with $800? I mean, I'm sorry. I don't mean to be, but I saw your video and I was like, oh my God, this guy really knows something. And my lawyers keep saying, oh, we don't want to fix up the judge. I'm like, fuck the judge. Oh, I'm sorry. I'm so sorry.
No, it's okay. I mean, it's registered for adults. So yeah, if there's a 5-year-old watching this, somehow their parents not watching what they're doing. So you're good.
I know, but I'm sorry. Let's leave me out because there's no human being. $800. I live in New York State, by the way.
Oh God, it's so expensive.
What do you think $800 is going to get you in New York State?
A closet.
I mean, let's be real. I can barely pay my bills. So how I lived this long is beyond my comprehension on earth. But
okay, so I have a list for you of how you can fix this. Number one.
Oh my God.
Find out. Call the SSA and find out what your DLI is. So tomorrow morning, call the SSA local field office. Hello, SSA. Hi, Mary Poppins. What's my date last insured? My DLI.
I did ask that.
Okay. What did they say?
They said that at that date that I became disabled, I was fully insured.
Yeah, but we need to know the exact date.
My lawyer asked them to find out. And at that time in 2014, I was fully insured.
Well, 2014 doesn't matter because this whole claim, like you were filed for SSI on 2/24/15, and you were found disabled on 9/5/15. Yeah. So 2014 doesn't matter. So let me ask you this. Yeah, if you read through that, that's why I had you read it, because there's some problems. When you were telling me, I was like, wait a minute, the math is not a square into a circle right now. So help me out with this.
So something's wrong here. Like,
massively wrong. This is like, dear God, Armageddon.
I mean, why should I not be able to get? First of all, I mean, look, I can't hardly walk or
No, I get it, and that's
drive
all right.
a vehicle.
Let's.
I'm not like laying down on the ground, but like simple tasks that you do like without thinking.
No, I know.
Bringing a
You can't
bag
do stuff.
upstairs,
I know.
I
got it.
breathe.
14 somewhere. I need to know the exact
DLI.
date. DLI, date last insured, DLI. If I know what the DLI is, I can help you get through the next really important section. So find out what the DLI is. Next thing, let's play some hypotheticals. Okay. If your DLI was in 2015, what you're going to do is, whew, man, this is tough. All right. So
I know.
Yeah. I'm trying to think if I screwed up at this level, if I made this big of a mistake with a claim, how would I fix it? The way I would fix it is, all right, this is how I would do it. No, it could be done. It could be done in one of two ways. Way number one is you file an appeals council review, and that did not properly file you for SSDI benefits, and that you want that claim as your SSDI Title II claim, joined to your SSI claim.
So both together?
Yeah. Every single claimant I file from both SSI and SSDI. That's how I do it. That's how everybody's supposed to do it. That's how you cover your butt.
Didn't my lawyers do it?
Well, that is an excellent question that I do not know the answer to.
My notice of decision, partial review. And the only thing he said in these papers was that I could raise my arm over my head. I was like, what?
Well, that's neither here nor there. But
then you put then they had the guy on the phone.
Okay, but let's go back to what we need to do. You have to file an appeals council. Now, how long ago?
January 31st, 2018.
2018. God, that's like 2 years. No, that's like a year and a half. No, that's 2.5 years away. Fuck. I mean, that's not even gonna work.
1999.
That ain't even gonna work. Yeah. So what you would normally use is what's called the 404.911 statute. Like think 404.911 is the statute you would normally use for this terrible, horrific situation. And it's called the extend the 60-day allowance, because you get 60 days to appeal that claim into appeals council.
I called my lawyers immediately. I wanted to appeal it. I called them many times even after that. They kept saying, "Oh, we're afraid he's going to take it away." Like they were like backing away, saying, "Oh." Everybody there tells you something different. I mean, I cannot tell you how many people I spoke to at Social Security, and every person tells you something different. And I'm like going, don't you people like know what the hell you're doing? Like, did you take a course to get this job? I mean, what the hell are you doing? At one person to give me the correct answer to anything. And I find that to be incredibly crazy, to be honest with you.
All right, so
as you wait over an hour to get somebody and you don't have no idea what the hell they're talking about.
Yeah, I can't say what your law firm did or give them schmooches or give them bonuses or tell them they're horrible. But I'll tell you this. You really got to find out what your actual date last insured is.
Okay.
The only way you can fix this at this point is by doing trial tactics / did you do your 9 months of trial work period?
Of what?
All right, when you get found disabled, you get 9 months of trial work period, which means that you get to work and still receive benefits for 9 months.
No, I didn't. I can't. I can't work. I can't stand.
All right, so here's the deal.
So,
this is the only way you can actually fix this. This is the only way that you can fix it at this point, because the appeals council is, why the hell didn't you just fix this over the past 2.5 years? And you're gonna be like, oh, I don't know.
Well, I did. I did so many times with my lawyers, but they keep saying, what did they just take it all away from you?
Well, they're going to want to know, why didn't you fire your attorney and then figure it out and say, hey, I should have had this?
Because I'm an idiot, I guess.
You know, my dad would always ask me, how could you be so stupid to do that? And I learned when I was about 12 that the correct answer was, you're right, I'm an idiot.
I
Yeah.
mean, I don't know and understand when my lawyers would say, okay, you know what, if you were fully vested or whatever, fully insured, and yes, we'll go back and fight it for you. Maybe they didn't have, I don't know. They were paid plenty of money, I'll tell you that. I was left, as I told you, with $197. Everybody was paid out, which is absolutely psychotic. I mean, my best friend.
All right, we're getting off task. We're getting off task.
$35,000.
All right, we're getting off task. So the only way to fix this is to go and get a part-time job and earn more quarters of coverage. I don't care where you work. I don't care if you're doing the most basic, stupid, simple job. But in that 9 months, you've got to earn 4 quarters of coverage worth.
What the hell kind of job?
I don't know. You could work at, a place where they make chocolate, donuts, bears. It could be a place that does services. I don't, whatever. Just find a job where they have very, accommodations that work with you.
Okay. Well, I have got, just due to COVID-19, there's so many places closed down where they help you back to work program through SSA.
Mm-hmm.
And, they're obviously not there. They're not in the office. Nobody is in New York, remember?
No, I know,
So
but you're
going
going to, once we're done with this whole COVID thing, which obviously who the hell know, who knows when that's going to be. There's going to be a second wave of it, hence second wave masks. Anyway, so, oh no, I lost the mask. So what you know is it's over. During 9 months of that time period, you need to work, you need to earn at least 4 quarters of coverage worth. Now, why is that important? I will then go ahead and basically, so what you're going to do then is that'll push your date last insured forward year by year in time. So for every quarter of coverage you earn, it'll push your date last insured forward. So if your date last insured was in 2014, it'll push it 4 more years forward to 2018. If it was in 2015,
9 months.
Yeah, because if you can earn 4 quarters of coverage in a single year, then the next year they apply it, and then you get that their date less insured will move forward. Doop 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 doop.
They take money out of my Social Security income. I think they let you have 85, and then
in 2020, SGA 2020 amount. I never remember these. All right, so $2,110 for blind. Is it for statutorily blind individuals? Is 2,110 for non-blind individuals? The monthly estimate for 2020. All right, you're going to have to earn. And let me get out a calculator because I'm part of the millennial era. Actually, I'm not. I'm slightly too old for it. But I like to say I am because I can blame my terrible math skills on it. You're going to have to earn.
Well, you should see the new math. It's ridiculous.
No, I know. Trust me. I had to do it in my MBA, and it was misery.
Oh, God.
Yeah, I got an MBA in a single year by doing 22, 24, 23, and 26 credit semesters. I did 2 of those during summer.
I think Einstein himself would absolutely laugh at that.
Yeah, which is what everybody else just calls daydreaming. And yet during his thought experiments, he saw theories of physics far beyond the capacity that anybody could ever imagine, and he did it in a couple of writings in a super short period of time that all turned out for the most part to be true, which is just mind-boggling. The only thing that it contradicts is string theory. That's totally different. All right, so you have to earn digging a hole, whatever, it doesn't matter, just you got to earn in a job $5,040.
Oof.
That's what you've got to earn in a 9-month period. That's what you've got to earn.
5,000. How am I going to do that?
So that's what you've got to earn. Hey man, look, you wanted the solution. I'll tell you how to do it. It's not pretty, but at some point after 2018, be like, how am I going to fix this? And you didn't fix it. So now you got 2.5 years.
I tried.
Yeah.
Believe me, I tried.
Yeah. Okay. So here's the deal. Okay. Now.
Should I try to find another lawyer?
I mean, you're talking one right now, so this is a good start.
Well, that's true.
Yeah. So, but let me walk you through. Step 1, find out what your DLI is. Step 2,
Okay.
find a simple, stupid job. Like I'm talking like, they give you a bunch of accommodations. You get to do whatever you want. Cha-cha-cha, yada, yada. But no, I'm not going to say politically that, but it's a super liberal state.
I live upstate New York, so
yeah, there's tons of too, even in the woods. Well, that's upstate New York, right? Beautiful mountains, streams, lots of snooty people. That's upstate New York. I grew up in New Jersey in the farmlands. I'm not talking upstate New York farmlands. I'm talking like the cow farmlands. I'm talking
Hudson Valley.
Oh, okay, all right. Well, you still you find something.
Albany.
Yeah. Well,
I'm not that far up now. But I'm closer to Albany.
Yeah. All right. So. Yeah. All right. So okay, but still, there will be jobs available, and as a tri-stater, you should see what's out there. Now, look. Remember, you don't have to just get one job. You can do one job that's part-time, another job that's part-time, but they can be stupid, simple jobs. Find a friend that they are. Into 2021, that amount's going to go up slightly. So just think $5,500. That's what I've got to earn around. Okay. Just think as a general $5,500. So what that means is, hey, Kayleen Peters, I am answering questions. I just got to do this phone call real quick, and then I'll pop back to you guys. But
I'm really sorry.
No, you're fine. So what that means is that basically, if you can earn another 4 quarters of coverage, and it was like 2014, then basically it'll move your DLI, your date last insured, the date we've got to prove just before it that you were disabled, from 2014 to 2015 to 16 to 17 to 18. That's good. But here's the problem. 2018 is too far back. 2019. Because then you can attach to 2019 at the very beginning of it using the 17-month retroactive benefit. I know this is complicated, but just write it down. That way, if you call another attorney in your area, you can run it by them, and they'll go like, oh, okay, maybe, yeah, this could work, blah, 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 blah. So you've got to basically get 5 total quarters of coverage. That way you're covered. Now, if they come back and they're like, your date last insured is 2016, you're set. Just go earn the 4 quarters of coverage. That puts your date last insured all the way to 2020. You're good. But if it's...
they told me I was fully insured in 2014.
That's cool, but then you need 5 quarters of coverage. Maybe 6. You'd have to look at what the months were. So, and you can always look. You can always shoot me an email tomorrow. Like, call me, this is my DLI. And I'll tell you, like, this is what you got to do. So what that means... Right. Yeah, go ahead.
Where's your email? Is it on your...
It's on the thing. It's like, yeah, it's wrh@disabilityresolution.com or info@disabilityresolution.com. It's on the little bio thing. Just email me what your DLI is, and then tomorrow I'll go ahead and basically just email me what your DLI is, and I'll send you step-by-step what you need to do.
All right, I'm trying to find your email. Subscribe, about the law firm. Disability info, evaluation. Attorney.com. No.
Do you see a part where it shows numbers?
No, it's like.
All right, so look at the chat. This is the email.
Yep.
You can send it to that one, or this is my direct email. But remember, when you send it to my direct email, back office didn't know to yell at me to look at it. That's the truth. Yeah.
Do you mean whoa.
So I just put it in the chat. disabilityresolution.com. Yeah.
Oh, I got it. Okay.
Perfect. Shoot me an email with what your DLI is. I will then basically go ahead and send you your step-by-step on how to fix this thing. So that I feel like, the stars are aligned and life is wonderful, because it helps me compete against the big box firms that spend tens of millions of dollars on basically, advertising. Because I can't spend tens of millions of dollars because I have a boat addiction problem. I'm going to be honest with you. So
you have a what?
I have a boat addiction problem. It's turning into a yacht addiction problem, which is the final stages of marine.
Okay.
Yeah, it's a bad.
Wait,
yeah.
well, now it's passing me by. Oh my God.
Yeah.
Wait a minute. I can't get the big email. It went away.
Oh, here, I'll put it in there again. Oh, because I can spell. Hold on, I gotta redo it.
Okay.
Boom. There you go.
Oh, resolution. Okay.
Perfect.
Okay, so you want me to get my DLI? Okay, which I'll be on the phone for 2 hours.
Yeah, get the DLI. Yeah, then just email me, and then I'll email you step by step what you need to do next.
I think I need a new attorney.
Well, yeah. I mean,
but
it's
but
tricky
you can't
too.
be my attorney because you're not in New York State.
Well, here's the thing. No, I mean, I can be your attorney anyway. You could be in Guam, and I could be your disability attorney. Of course, come to your hearing in the Virgin Islands. No, I'm kidding. But in the Virgin Islands, they don't have hearings. They only have them in. You can actually fly to Florida. Those are your two options for having a hearing for disability benefits with the Virgin Islands. And the Virgin Islands doesn't have SSI benefits. They only have SSDI benefits. SSI benefits are called a different thing, and it's specifically through the Virgin Islands, which is totally neither here nor there. But I've done those claims too. So, you know. All right. So
can you do a claim in New York?
Yeah. I just remember I have so many hearings that I have to look and see if it's like, because remember, this is not a standard claim. This is an appeals. Well, no, actually, this would become a standard claim because you'd have to refile for SSDI benefits after you got enough quarters of coverage.
Right.
So I'll walk you through it. Just give me a call. Whatchamacallit, tomorrow for your day less insured is.
Okay.
Perfect.
I'll find that out.
Excellent. Madame, I will catch you later. Have an absolutely wonderful day, and we will go from there.
I'm your time. I really am.
No, it's okay. I do this until 10, so whoever calls in, we do it anyways. So 8 to 10, it's you guys, and then after 10, it's my dogs, and then after 10:30, I brief. Yeah. So yeah,
Okay. So info at disabilityresolution.com.
Perfect.
Okay.
Excellent. Alrighty. Well, have a wonderful day. Yeah. Go ahead.
Thank you so much. I mean, absolutely. Thank you so much. But if you could, boy, if I could get you, and you get paid no matter what.
Greatly reduced because you're already receiving SSI benefits. So if you only receive
What happens while I'm appealing? Do they take that away from me?
No, you get to keep.
Because if I'm fighting with them, are they just gonna zap it away?
No. You get to keep your SSI benefits while you're actually filing for SSDI benefits. You're fine. They're not going to take your benefits away.
Okay. Because this would save my life, literally.
No, I hear you.
I mean, can you imagine living on what I'm living on? I have a dog. I have a cat. My dog is going to turn 12 years old.
Yeah.
She's a purebred. How much time do I have left with her? I mean,
I don't know. But no worries. Give me a call tomorrow.
I see how much you love your dogs.
Oh, I love them too much.
All right.
Oh my goodness.
Love bugs.
All right. Well, no biggie. I will catch you tomorrow. Shoot me the email.
Right, so you want me to send you an email, or can I call you? Or
yeah, you can call me. Yeah. You use same number, cool. Same gig. I use what's it called? Google Voice right now, because with all the telephonic hearings, it actually does a better job keeping me connected than if I just use a regular cell, or if I use Cricket. For some reason, it was just disconnecting me left and right with the hearings. So that's why I use Google Voice, because it just seems to do better with the hearings and not disconnecting me during the hearings.
Right. So what number should I call you on if I wanted to call you?
Just this one, 407-279-1754. 407-279-74.
407-279-74. 279-754.
Right.
Because that's not the other number that you had up on your regular page.
Right.
I don't know.
No biggie.
Okay, so but during the day you're like around.
Yeah, I mean, yeah, I do this stuff all day. So, I mean, and night, which is what causes horrible relationship problems. But yeah, I'm around.
I can imagine.
Yeah. I
mean, if you work until 10 o'clock at night, I mean, it's time for you to, like, take a rest.
Yeah. Yeah, I agree. All right, no biggie. Well,
but you're doing a good service to people, and you're absolutely amazing.
Thank you. I appreciate it, you know? Oh, my goodness.
And now, where can I give you those stars and all that kind of crap? Like,
so
well, here's your thumbs up.
Yeah.
Right here.
So if you Google just like that, basically, you can go ahead and just click it, or you just click on the right side, and then you can leave the 5 stars.
Okay.
Perfect.
Got it.
Excellent. All right.
Got it.
Madame, I will catch you a little bit.
Thank you so much.
Absolutely. Have a wonderful night.
You too, sweetie.
Thank you.
Thank you so much for your help.
Thank you. Bye-bye.
Bye-bye.
Okay, guys. So real quick, something that was I was noticing about this bottle was that it says flavored juice drink from concentrate with other natural flavors. I thought Snapple was a tea. When I was growing up, Snapple was a tea, but it's not a tea anymore, right? Because it's apparently made with too much concentrate. That's basically what's going on here. Yeah, 5% juice. On my writing, which tells you I had a pretty good childhood. So, all right, here we go. Let's see. So, oh, here we go. Hi, this is Attorney Walter Hnot. Are you ready to run some questions? Oh, I got to do the button. Hi, this is Attorney Walter Hnot. Are you ready to run some questions?
Yes.
Okay, now is this a gig where you want to run hearing questions, or you just want me to answer something that happened?
This is overall gaming.
Okay, perfect. So do you want me to go ahead and run hearing questions with you, or do you have something that happened as part of your hearing process for disability benefits that you just wanted me to clarify as situational analysis?
Yeah, a little backstory. 2016, I suffered. And work. It took me almost a year to get surgery for that.
Mm-hmm.
Hello?
Yeah, no, I'm listening.
Okay. And during that process, I continued to try to work. I just got promoted at my job. I was a professional traveling dealer.
Mm-hmm.
So, like, floor job, big money.
Mm-hmm. Sure.
Everything was going good up until that happened. I continued to work, but I stopped traveling. I got an online gig to try to help offset some of that money, because obviously I went through therapies, multiple doctors, specialists, and my last day to work was 9/9/19. That's close as I can remember.
So when was it? What year was it again?
My stroke.
No, what year was the last job that you worked?
9/9/19.
Okay, so 19. So September 19. When did you file?
January 7th to 2020.
January 7th, 20. Okay, when's your hearing?
I haven't got that one. I'm under consideration process.
Okay, so you're in the early stages. Okay, so
Yeah.
all right, walk me through this. What question do you have about the reconsideration disability process?
Okay, hold on. Let me get my paperwork.
Yeah, sure.
So, here it is. So I went out the virtual application. I didn't, obviously new to this, did some research. Said I was able to do light work. I said I was disabled because of blind, low vision, strokes, muscle spasm, chronic fatigue, migraines, nerve pains, and fibromyalgia.
Mm-hmm.
And then it says, the medical evidence shows you have a history of fibromyalgia, depression, anxiety. I just started seeing a therapist recently. Obviously, with COVID, a lot of my doctor's appointments are months away because they're overbooked because no one can go see anybody.
Right.
Another tidbit was I had applied for SNAP benefits. You know, honestly, if I'm not working, I have no income, I have to eat. So,
Nope, I lost you. I don't know what happened there. Hold on. Let me go ahead and get back. This one. Call. This one.
You have reached the voicemail box.
Let me try them again. You're not reconsideration. You're wondering, what's my likelihood of being found disabled at reconsideration? And you're going through this section of like, oh God, if I get a denial, what am I going to do with the hearing? Is that kind of what's going on?
Well, some of the stuff they didn't have in the report, obviously, they didn't have my they didn't have my rheumatologist report.
Mm-hmm.
I got a new rheumatologist, but like I said, because of COVID-19, all been pushed back. Even the psychiatry appointment has been pushed back.
Mm-hmm.
So I didn't know about the depression or the anxiety, but more I have read up on it, I fully understand. You know, I just denied that I wasn't a depression, I guess.
Okay. All right. So the claims starting to develop.
Back to the SNAP in my state, you have to go through their work training program, okay?
Mm-hmm.
To try to get a job because they try to get you off the SNAP, you know? So I had my doctor write a note out. I put it in with the application. Then they came back to say the state has deemed you mentally frail. A person may be receiving benefits under another program, they'll be not be entitled under our rules. This may be true in your case. I think that's what they were referring to. I can't be 100% sure.
So read that statement one more time.
It says, may be receiving benefits under another program and still not be entitled under our rules.
Okay.
This may be true in this case.
Yeah. So some programs require more stringent medical requirements to be found disabled. A lot of people who think that they're found disabled through workers' comp are automatically going to be found disabled through disability. That's not true. The standard for disability is actually much higher than the standard for, so, okay, no biggie.
So, they said I could do light work, back, went to a chiropractor. That was submitted as part of the report, even though they don't hold much weight.
Mm-hmm.
All my new x-rays were totally different than the x-rays of 2016, like my spine x-rays. I've had an MRI on my neck, which came back with C5 something, slight bone spurring.
Mm-hmm.
I don't know what the term is. Do you think I need a full MRI of the rest of my back to make sure? Because the chiro said I got some degenerative disc.
Well, I mean, first thing is chiropractors are kind of like witch doctors for the purposes of adjudications before the Social Security Administration. Mm-hmm. So you're not getting weight of testimony at a doctor level. They're considered like a nurse. Yeah. So do you have health insurance right now or no?
Through the state.
Okay, so then I would definitely...
And that was part of the problem is over the last couple, not to interrupt you, sorry.
Yeah, no, go ahead.
Over the last couple of years, I've lost my insurance because they never sent the forms out to reapply because my income dropped from, was making like a quarter of what I was making the previous years. Obviously, I was a traveler since 2016. And then I found an online job. And what happened with that was that they had my contract ran up for what I was doing. I started applying for other jobs because I couldn't stay focused because of the pain.
Let's do this.
I was wondering.
Yeah. Okay. Go ahead. Yeah.
I was trying to figure out this paperwork because it then says something about substantial employment. Because I'm not sure what my date is that they think I worked or.
So basically, you're earning over 1,000. I think it's two. Hold on, let me look it up. For 2020, SGA is $1,260.
Mm-hmm.
So what that means is they're looking to see if you're currently earning any money. And if you're not earning any money, you're not earning SGA, which means that it's easier to find you disabled.
Okay. Are you saying that I was making that much, so therefore I don't,
No.
I'm not sure what
I'm
date
saying
I
is,
actually put as my onset date.
When did you stop working?
9/9/19.
Okay, so around then is likely when you stopped earning SGA, which was substantial gainful activity. Going forward, essentially, whether or not you are still earning, SGA. You're not, because you're no longer working. So now they're looking, okay, how far back can we go for this Title II SSDI claim? Can we go retroactive benefits even farther back? And if we can, then potentially they run into what's considered your SGA, your substantial gainful activity. They cannot make a month that is your amended alleged onset date, right? Do you know what an AOD is, alleged onset date? Next week, and we can start off with your phone call, and I can kind of walk you through things.
Mm-hmm.
Perfect. Let's do that, because your claim is going to require me to explain alleged onset date, protective filing dates, retroactive benefits, things like that. And if you don't have,
I looked that up on the website. Can I see the original application on the website?
Yeah, you're going to need, basically, when you initially filed, you're going to need to know what your date last insured is. You're going to need to know the last date that you earned over $1,260 per month.
Okay.
Mm-hmm.
Well, my type of job is like a poker tournament usually lasts 10 to 12 days, 2 weeks.
Mm-hmm.
We work every day. Tournament, called off them, and I always left early as possible.
Oh, okay.
Just because of stuff is getting harder for me to do.
Right. Gotcha. Okay. All right. Well, excellent. Excellent. Well, good, sir. Let's do this next week. Catch up with me. I'll go through all the details with you. Go collect those things in the meantime, and then we'll go from there.
All right. Thank you so much, Walter. I'll do that.
Thank you.
Have a good night. Thanks for everything you do for all these people that need help.
Absolutely. Thank you so much. Have a wonderful night, and I'll catch you next week.
All right. Have a good one.
Thank you. Bye-bye. Okay, guys, we've reached 10 o'clock, which means that it is now time for the dogs to go outside and basically attack the wonderful wildlife that comes across the property. Tonight will likely be a squirrel. And remember this. I'm just waiting for the connection to come back. Remember this. Do you guys want to go ahead and basically call in, have questions, run hearing questions? That's fine. I'm available. 407-279-1754, and you'll be good to go. Have a wonderful night. I'll catch you later, and we'll go from there. Thanks so much. Bye-bye.